Welcome to this week's Jackson County Board of Commissioners meeting. Your Board of Commissioners, overseeing these dedicated county departments. And now, your county commissioners, working together for the citizens of Jackson County.
Good morning and welcome to the Jackson County Board of Commissioners session here, December 7th, 2011. It's that day of infamy that started World War II and the Japanese bombed Pearl Harbor. This is 9:30 a.m. at the Jackson County Courthouse Auditorium. I'd like to ask that we all rise for the Pledge of Allegiance, and I'd like to ask Don Roulette to lead us in the pledge. Don?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Don. Okay, now we have our award. Hi, Jim.
Hi, how you doing?
Come on, stand right there if you could, please. You got your rooting squad here.
Yeah.
All right, that's good. This month, we wanted to feature Jim Strasser as our December 2011 Employee of the Month. Jim has been with the county since June 2006. He currently works in the Jackson County Jail as the maintenance assistant. Jim is one of our most valued employees. He brings a great deal of work ethic and team player attitude to work every day. Over the past 6 weeks, Jim has stepped up and taken on the role of senior maintenance worker, while his co-workers have been out on leave. Jim has taken on all these responsibilities in great stride. He's had many long days, and keeping up with that is typically a two-man job. His above and beyond efforts have not gone unnoticed. After talking with Ace Lockwood, he's not at all surprised about Jim stepping up and taking care of business. Ace stated that Jim never complains and does what it takes to get the job done. Lieutenant Christine Bronson, jail commander, was quoted, "Jim is a great asset to the jail, both filling in for Ace and working with Ace. Jim is always pleasant and upbeat. He is quick to respond when asked to complete the task. We enjoy having Jim in the facility, not as a guest." I added that, not as a guest part. We look forward to Jim continuing his work ethic and service to Jackson County. Great work, Jim. Congratulations.
Thank you. Well, we'll leave the glib to my fellow Commissioner John, but you know these Employee of the Month recognitions are something that supervisors and employees, the employees' peers recommend. So this is something that the folks that work with Jim here and work with him and for him recognize your good work with all these Employees of the Month. So congratulations for that, so that your peers think you're pretty doggone good. Thank you, sir.
Jim, congratulations. You know, I always do a little research on these, and I hear all the good things you do over there. I'm a little disappointed to find out you're ex-Air Force. Don and I are both Navy. CW's Air Force, so we've got to. I
did start out Army, and then
Oh, did you? All right. And what a lot of people might not know is how much work you do for the veterans, and I really appreciate that. You're really involved with that. And on another note, I find out, you know, this is related to the new ordinance we just had in White City, but I understand you have miniature horses and miniature goats. Is that right? Yeah, all right. So we've got those protected now.
Good,
so
good.
anyway, I appreciate what you do.
Appreciate
Yeah,
it.
yeah.
I'd just like to thank everybody and their support and everything, and I'm just doing my job. That's it.
You do a good job. Thank you, Jim.
Our first item of business is item 1000. This is a request for and discussion of non-agenda items. There is a 5-minute limit. Members of the audience may address any item not on the agenda. State statute prohibits the Board of Commissioners from discussing a principal subject that is not on the agenda. But the Board of Commissioners does listen to your concerns and may ask staff to follow up on any questions you raise. An extension of 5-minute time limit may be approved by the majority of the board. With that said, anybody wishing to come forth and talk about any non-agenda item? Any non-agenda item, please come forth and please identify yourself, your name and address for the record.
Mr. Chair, could I ask for clarification? Anyone that would want to speak on the coordination process, there's a section down below.
Yes, there'll be that. That's on the agenda, and that's open for the public testimony as well. So, yes, sir. Yes, sir.
It's on.
Yeah. It's on.
My name is Wayne Bennett. I live at 2495 Republic Way, 97504. I wanted to speak today on, I'm nervous. I shouldn't be. I know two of you, but I'm still nervous. On non-funded
unfunded mandates?
Mandates, thank you, CW. I am nervous. On non-funded mandates, we have in this county, in the church I go to, we have 8 NA and AA meetings each week. Averages 250 to 300 people each week at our that we house. Now, I know that we're not going to talk religion here, but all we do is furnish a meeting place for these AA and NA meetings. I've talked to Dennis and Mr. Smith and Mr. Skundrick both on this subject. Mr. Smith called Mr. Jordan here a couple of years ago, and Mr. Jordan says, no, we don't have any money for that. And the cost of housing these NA and AA meetings, I'd like to hand one of these up to
Mr. Chair, can I ask for a clarification from the speaker about what I said we don't have any money for? I'm not quite sure what the issue is.
For housing or for anything to do with the NA and AA. Now, the county puts people in jail, and I'm sure it costs the county plenty to keep them there for DUIs and so forth. But when it comes to tell them they have to go to AA meetings, they're on their own. They have no place to meet. I went out to the county human services out in White City. They said they don't have any money. They thanked us profusely for housing these people, but they don't have any money. But we're furnishing the housing and the cost of this. Yeah, Mr. Skundrick?
Wayne, excuse me for interrupting, but by housing, you mean the meetings?
The meetings, yes.
Of facilitating the meetings, not physically housing, but holding the meetings for them to hold NA and AA meetings, correct?
That's right, that's correct.
Okay, thank you.
Mr. Chair, may I also interrupt real quickly, because I may be able to help Wayne with his issue here. I would find it odd that I would say we don't have any money for this, since I used to run the Community Justice Department, and the Community Justice Department makes meetings or rooms available, as we did when I was the director there for NAAA meetings. It requires a scheduling process for people that want to use the room. All county facilities as well are available to the public and nonprofit groups for utilization. Specifically, the library may be an option, community justice facility may be an option. There's a lot of options. I never talked to this gentleman, so I'm not sure where he got the information that I said we didn't have any money, but there's lots of opportunity. And if he's interested in meeting with me following this meeting, certainly could help him figure out where they may be able to utilize county facilities. I will say this, for some of the NAA groups as well, some churches utilize our county facilities.
That's our church.
One church.
Well, actually, there's other churches that use other county facilities.
They send their people to us.
Mr. Jordan, why don't we let him finish his testimony, and then we'll answer his questions.
Okay, we house, so it costs our church, $1,500 a month for heating, not counting lights and utilities and so forth. And we keep updating the facilities so they have a nice place to meet. But at $1,500 a month during the winter just for heating for a small church, it's become quite a burden. I'm here on my own. They didn't ask me to come here, and so I don't want someone to call that church and say, "What the heck you got him coming and talking to you about this for?" Because they don't even know I'm here. But it does become a burden when you're talking, well, at $250, say $250 a week. That's $1,000 or 1,000 people a month meeting there, and all the other churches in the valley. Our secretary says they call us and send them over to us if they want to have a AA meeting and so forth. So we are the primary. I'm sure there's some other places they could meet, but we're the primary ones because there's other places that don't want them. And so I was just hoping that there was some way we could have some support, financial support, to help alleviate the cost just of having a warm meeting place for them.
Okay, Chair.
And that's basically what I had in mind.
Thank you, Mr. Bennett. Mr. Skundry?
Wayne, if there was another option for these meetings to be held, for example, listening to the administrator say that there may be a county facility that would be open, scheduling or something, would that or is it a case of trying to continuing to hold those meetings at this facility? So my point is, what if we found another facility?
As far as I can tell, this is a choice of the AA and NA people that they appreciate and like where they're meeting. I mean, they've told us time and again that they're very happy with what we provide for them. So it isn't a question of us wanting them there or not wanting them there. It's a service that we do, and they make the decision of where they meet. We have nothing to do with the NA or AA at all. I mean, it's their choice, not ours. So I just don't have the feeling that the county has gone out of their way to make availability for them, because most places don't really want them, to be honest with you. You know, some of them are, when I go there in the evening and see them there's 15 or 20 women with strollers, and they come out between their meetings and have their smoke and throw the butts all over the parking lot. And, you know, I mean, sometimes the level of personnel that we have in those meetings, some aren't exactly what you'd call... Well,
Mr. Bennett, would you be available to talk with Mr. Jordan afterwards and maybe get some of those folks that work with those programs pretty extensively to talk about your interface, and that might work out really well. So, but we'll be in contact then. Is that all right?
Very much.
Okay.
All right. Thank you.
Thank you, Wayne.
Okay. Anybody else on a non-agenda item? We had somebody had their hand up for a non-agenda item. All right.
I just want to make reference. You mentioned today, December 7th, the bombing of Pearl Harbor. I just want to acknowledge again, they're getting fewer and fewer in numbers. And I'm curious, are there anyone here in the audience that are World War II vets? Well, I know there are several, obviously, in our community, and I just want to say thank you to each and every one of them. All of our vets are important, but because that number is dwindling over the years, just a special thanks to them and acknowledgement. And I see we have city councilmen here from the city of Medford, and I want to acknowledge, I assume that's the reason the flags are up downtown? because you're here. Jim, is that right? Okay, well, it's sure nice anyway. So if you had anything to do with it, thank you for that. That's all I have, Mr. Chair.
Okay. All right. There being no further folks that want to talk about the non-agenda items, we'll move on to our consent calendar, item 20.00. Item 20.01 is minutes of the meetings of Board of Commissioners staff meeting October 13, 2011, Board of Commissioners public hearing, regional problem solving minutes November 23, 2011. Item 20.02 is an order authorizing a sewer easement in favor of Rogue Valley Sewer Services, order number 257-11. Chair will entertain a motion on the consent calendar.
Mr. Chair, I move that we accept the consent calendar as presented.
I will second that.
Go to the second, call the roll, please.
Commissioner Spindler?
Yes.
Commissioner Rash?
Yes.
Commissioner Smith?
Yes. Item so approved and ordered. Item number 30.00, public hearings, 30.01. This is a situation where we have public hearing, and public testimony will be given during a public hearing, which is now, and shall be limited to 5 minutes per person. If you have additional information to give beyond the 5-minute limit, you are encouraged to submit it in writing. An extension of time limit may be approved by a majority of the board. Item 30.01 is a second reading and public hearing on the matter of consideration of an ordinance creating a new chapter 1231 of the codified ordinances of Jackson County, Oregon, relating to the federal coordination policy, ordinance number 2011-15. Danny?
Right, Mr. Chair, bear with me. I have a lot of information to cover here, which the board asked me to cover. First of all, first reading of the ordinance was made on November 23rd of 2011 at the 9:30 a.m. meeting here in the courthouse auditorium. As you said, this is the second reading and public hearing of an ordinance creating a new chapter 1231 of codified ordinances of Jackson County relating to the federal coordination policy. This ordinance will aid in protecting and enhancing Jackson County's economy while promoting the responsible employment of resources on and in federal lands. If adopted, the ordinance will become effective on February 6th of 2012, so 60 days, according to the county charter. Just to give some background on this information, this is actually an action that was initiated by the previous board, initially with Commissioners Walker, Commissioner Smith, and Commissioner Gilmore, and carried forward by this board. This has been a process the county's been engaged in for about a year and a half. Since about 50% of the land in Jackson County is owned by the federal government, multiple agencies, BLM, United States Forest Service, U.S. Army Corps of Engineers, Bureau of Reclamation, National Park Services, and other federal agencies. Those agencies undertake numerous actions with respect to planning and managing federal lands, and as we know, that includes things such as timber sales, endangered species listing, air and water regulations, mining and recreation environmental reviews concerning all of those actions. It's not limited to those things. This is a synopsis of some of those things. Federal law does require those, among other federal agencies, to coordinate with affected local governments regarding their respective planning and permitting activities and other federal actions concerning federal land. In an effort to ensure better compliance with the coordination requirements imposed by Congress on various federal agencies, in this case, the county's enacted the federal coordination policy to exercise its coordination rights to the fullest extent of the law. One of the issues the board asked me to cover is the difference between the county respectfully picking up the phone and calling an agency, which we do very often. We do have open lines of communications with all the federal agencies, versus adopting this policy is that this policy doesn't just encumber the county to pick up the phone and call. It requires the agencies to coordinate with us. And if they don't, provides a basis for the county to be able to take legal action or other appropriate action. This policy will provide a protocol for local government participation and planning for actions on federal land that affect the interests of the county and the interests of the citizens in the county. The idea here is to facilitate better coordination from federal agencies managing federal lands within a county. It is indeed especially important to do so, obviously, in the struggling economy that's dependent on responsible management of timber, recreation, minerals, and other natural resources. This policy is a 15-page policy today as it's written prior to your adoption, and essentially demands, but is not limited to, requiring the federal government to keep us appraised and keep themselves appraised on local land use plans, to consider local land use plans in developing their own plans, to resolve any inconsistencies between local and federal land use to the extent practical, and to provide an opportunity for meaningful local government involvement in the development and revision of land use plans, land use regulation, land use decisions regarding public lands. One of the other issues the board asked me to cover is the issue of how this may be useful to the county. As you've received comments about why can't the county just pick up the phone and call one of these federal agencies? As I said, we do often do that. However, we can only do that if we know about something that's going on. This federal coordination policy does make a demand upon the federal agencies to notify us, and they're required to notify us in advance of the public notice process. So many times federal actions get so far ahead of us being able to take an action or intervene or demand coordination because they're not exposed in enough time for the county to be able to act. This gives the county a basis to demand that we be notified prior to even going to a public process. You've also received some questions regarding why the county is enacting a general policy rather than seeking coordination on a case-by-case basis. The county does have the ability to seek coordination on a case-by-case basis, based on the fact that County Council has reviewed the statutes and made recommendations, as well as we hired an outside consultant to help develop the plan with the Board of Commissioners and with our Natural Resource Advisory Committee, who hired an attorney who specializes in this to help draft the plan. The better alternative was to enact a general policy to develop based on their legal opinion and based on the board's direction, and to execute a similar but more specific policy, then to execute a similar but more specific policy every time an anticipated federal action is discovered. And just to kind of summarize that, basically County Council told you that they didn't think that would be nearly as effective, although it is an option, in a legal manner, or in practical terms, as enacting a general policy each time on a case-by-case basis would be significantly more onerous than doing it in one fell swoop. And that's a summary of the legal opinion that you received on that. One other issue that you've been questioned on is regarding whether or not this is a land use decision. And one of the reasons why we brought an attorney who specializes in this is to make sure we didn't conflict with state land use law. The Coordination Policy Compact is not a land use decision or comprehensive plan, as these terms are defined in Oregon Revised Statute, Chapter 197. And the most important basis for me saying that is because the compact's only applicable where federal land ownership, federal projects, and or federal permitting requirements assign land use decision making to the federal government. So it's not a state's decision. With that said, Mr. Chair, just as a reminder, we do have someone here from the consulting agency who helped draft the plan with you and with our Natural Resource Advisory Committee when you get to the public hearings process. And also, Ryan's prepared to address some issues and change in the policy from the first reading to the policy what you're considering today.
All right. We have a representative from CSA, which was the consulting firm. Could Jay, would you mind?
Mr. Chair, first Ryan has some admonishments and wants to.
I'm sorry. Hold on.
Oh, pardon me. Yeah, and I could just reiterate this after Mr. Harlan speaks. Come on up, Mr. Harlan. After Mr. Harlan comments on this, I'll have a few comments just on the reason for the revisions that took place between the first reading and today, and then the board will open and close the public hearing and then proceed to deliberation and decision.
In a continuation of Mr. Jordan's comments, could you summarize your overview of what we're doing here today in 5 minutes?
Oh, certainly, Commissioner Smith. For the record, my name is Jay Harlan with CSA Planning, with offices at 4497 Brown Ridge here in Medford. I would just start my comments by saying I think Administrator Jordan did an excellent job of summarizing what was a pretty long process and has a lot of technical complexity associated with it. Briefly, I'd like to just speak to what the process was, and as far as really the content of the document. That started, we did, as directed by the original resolution related to this project, work closely with the Natural Resource Advisory Committee, which is the county advisory committee to the Board of Commissioners on matters such as this. We went to them initially, talked to them about the project. They elected to set up a subcommittee, and we worked real extensively with that. It was 5 or 6 person subcommittee of NRAC going through all the details of the language, and most of which has, from that committee, is now before the board in the form of an ordinance. Then their recommendation on a draft went to the full NRAC. They had a public meeting and an opportunity for the public at that level to provide comment. There wasn't actually anyone showed up to comment on it, but we would have welcomed any comment that would have occurred, and from that the NRAC made a recommendation to the Board of Commissioners. So that was really the process. It was, from a technical standpoint, we were working on really a lot of the research aspect and language things when it came to the legal matters. We had Robin Seafrid from Cable Houston, who does a lot of NEPA work and federal agency work as our legal advisor to the project. She did a lot of critical case law analysis and provided input from that perspective. So what does it really do? I think Danny did a good job summarizing what it does. I think the other piece that I would add is when the county picks up the phone to call an agency, several things as a result of this should work a little bit differently. And one is you should know a little sooner when you make that call related to a particular project. And number two, some of the basic policy foundation to start that dialogue with the agency then is in place. And so you're able to have, my expectation is the county will be able to have a more productive conversation sooner in the process. And that can really only benefit both the county and the agency over time, even where there are some pretty significant disagreements. Where there are projects that there's, broad agreement between the county and the agency, well, then that provides an opportunity even to start a discussion about, well, do we want to cooperate as an agency and actually be a part of the project? So those are things that can happen as a result of that, but I think this will compress the amount of time that the county is able to get to meaningful dialogue with the federal agencies, and I think that's what it does, and it will advance the county's interests in that way. I'm available to answer any technical questions or questions about how the project progressed to this point. There may be technical questions come up that we don't have precise answers for today, as this is the first public hearing on the matter, and I would leave it to you to deal with those.
Okay. Do you have any questions?
Well, I was just going to say, maybe after we take public testimony, if something arises there, we may ask Mr. Harlan to come back up.
There may be some unanswered questions.
Yeah, Mr. Chair, just let me add one more thing, because I think it's important for the public to have more perspective on the ordinance. This is just the ordinance. This really is the foundation for the county to be able to take a position legally or otherwise if we're not consulted and coordinated with. However, there's other documentation that will support this process that you wouldn't adopt as part of the ordinance, but you will do as part of policy activity. And specifically for the public, one of the things that our consultant did, which is very useful to you as a board, is create a guidebook. We wouldn't adopt a guidebook as part of an ordinance. However, it is a reference material or a reference document that is very useful in identifying how we may proceed, giving any specific set of circumstances from any of the specific federal agencies. Now, that document isn't part of this hearing because it's not part of the ordinance, but it is a public record, and it is something that will help the public understand how you might choose to proceed in any given circumstance. Also, that document at this point is still in draft form because you haven't approved it, so it's not available to the public yet until you have approved it, and we will anticipate that being approved prior to the effective date of the ordinance of February 6, 2012, any time between now and then. And just want to make sure that people understand this is not all that the coordination is about in terms of the county's activities.
Thank you.
I think that's an excellent point. Is after the county sets its policy, then you have an implementation component. The guidebook is one piece of it, and it's also the other piece of it relates to county resources, and those are things that you and the county staff work out on a regular basis.
And I would add that it, as a guidebook and not as a formalized resolution or a formalized ordinance, it's much easier to adapt and change and modify as we get information on how we can proceed on various aspects.
I would expect there's, I think, somewhat of a learning process that will go on here at the implementation level, and I would expect that to occur. Yes.
All right, Jay, if you'll be available for questions. Yeah.
Thanks.
I know I only said one more thing, but since you said that, I think it'd be useful for the public also to know that because you're adopting this as an ordinance, you have the ability to go back and amend your ordinance. So through the process of learning and interacting with the agencies, if there's something you adopt in this ordinance that doesn't work or something you don't adopt that we need to go back and add, you always have the ability to do that. This is set in stone as far as you've approved it as an ordinance, but you always have the right to go back and amend it.
Yeah. Thank you. Thank you, Mr. I now call on County Council to give us our admonishments and for our public hearing.
Thank you, Mr. Chair. Like Mr. Jordan said, there's a formal legal platform for coordination between federal and local governments, and to reiterate, that formal platform that's allowed is created by federal law. This ordinance creates that platform. It's just a step in the process to effectuate the rights that Congress has given local governments to receive coordination efforts by these federal agencies. Now, the draft ordinance has been revised since the first reading. The revisions were entirely clerical and scrivener in form. It included removing the appendices from the first draft and citations to legal authority and language that was more explanatory than substantive. None of the changes that have taken place in the revisions change the effect or substance of the ordinance. And so if there's any questions on that, feel free to ask, and hopefully that all makes sense. Now the board will take public testimony. At the close of the public testimony, they'll close the public hearing and proceed to deliberations. Thank you, Mr. Chair.
All right, thank you. Mr. Skundrick of Council. Or Mr. Rasher of Council.
Well, I have a procedural question. I think it's for Council. In theory, we would be done with this today, but if we hear something today and we want to modify this, does that mean we go to a third meeting, or can we adopt it with the amendments that we hear today?
Good question, sir. The decision that you make after the close of deliberations includes to approve it as written, to deny it, or to continue the proceedings for further amendments or revisions.
So we would have to have another public meeting?
Yes.
You could also approve it with amendments. However, those amendments may be things that you may want to take public input on.
Okay.
All right. Got that. All right. Any questions of legal counsel?
No.
All right.
No.
Ladies and gentlemen, at this time I will open the public hearing, and we stated that this will be limited to 5 minutes a person, and if you have additional information to give that to the staff here, and that'll be included to submit it in writing. I will say, as a prerogative of the chair, I will allow Commissioner Skundrick to make some additional comments he wanted to try to get in and say as we proceed. So if you don't mind, just hold on just a second. So.
Well, thank you, Mr. Chair. I just want to make clear that there was a little hyperbole in the newspaper the other day about the county flexing its muscle. I thought that was interesting, and it also quoted me as saying, which was a correct quote, that I said in our first reading, as I said, this is a little bit like spitting in the wind. I wanted to clarify that, in that I'm firmly in favor of this as we go through and we deliberate this. But as explained by the administrator and our consultant, this has teeth to it. I just wanted to kind of clarify that comment so people don't think this is just a superfluous exercise. So with that, Mr. Chair, that was it.
Okay, thank you. Thank you, Commissioner Skundrick. Please identify yourself and your address for the record, because we'll need to record that. So, okay.
Good morning, Commissioners. I'm Ken Fawcett, 55 Scenic Drive, Ashland. I'm also a member of Americans for Prosperity. I welcome this opportunity to speak, and like all of you, I fully support that we're going into coordination or implementing the tools so that we can do that. As I think about coordination, one way to look at it, I believe, is that every time there's a project of any size, there is an evaluation done of the impact, and it always looks at water, soil, and air. But there's one part that's missing, and that part historically has usually been the communities and the water boards and the school districts and what the impact is on them. So coordination was really the answer to that, and back in the 70s, that's where it came into being, and it gives us the right, therefore, to be equally represented with all the other natural considerations. For example, if the stream flow were to be diverted and reduced, we know that the fish would be well represented by some federal board, but the community wouldn't necessarily be there. With coordination, we are equally represented, and so we can bring forward the economic impact, the recreational impact, etc. So it's a pretty powerful tool. With that in mind, when I look at page 3 of this, while you could say it's semantic, that when I look at page 3 and it talks about the purpose of our federal coordination policy, and it says it's to assert our rights to coordination and to put in place tools and procedures that empower the county, to develop meaningful and productive relationships with the agencies. I would argue that the purpose of this is to put in place coordination in order to give the county the tools to fully represent the economic, cultural, and other interests of this community. And I think it's important that we take that strong position. It's a little, in response maybe to your spitting in the wind, I think we have something that's going to be real important in the years to come, so we should start there. Next, there is reference to achieving consistency between federal and local plans and policy. Well, as I see it, I'm not sure what a plan is, and that's where I would target and say that perhaps we need to define what we mean by plans. I wouldn't want to see us go in and try to achieve consistency or agreement and discover that those plans didn't cover our economic goals, or in other words, that if the bar should be up here, let's be sure that whatever a plan represents, and perhaps Mr. Harlan can further define what that is. And it suggests to me, and maybe it's the handbook, but it suggests to me that there might well be some other documentation that's required to be on solid ground in terms of going into coordination. And then as I look further through the document, that I see some areas that seem to reference what the federal agencies may or may not do, and some of it I think, you know, in that perfect world, maybe I would edit them out and maybe some others would. And I have a 5-page document here which I won't bore you with, but there's some important points here, and I'll talk about this in just a minute. But what I do like is I see in there that it talks about things like achieving sustainable yield timber harvests. And I think that's important. That's making a statement about who we are and what's important to us. It talks about maintaining and restoring grazing rights. And again, I think that's about who we are and our economic vitality, and so that's good. On the other hand, I go down to page 10, and it talks about air and water resources. And in my simplistic way of looking at it, it's fairly neutral about what that's all about. It says that we will look at the way it's presented and go through the normal routines and we'll accept things. In my opinion, that water is perhaps one of the most vital concerns for this county, and that we should be making a statement there, as we do in some of the other section, about water and agriculture, etc., and not just leaving it blank. So I see some inconsistencies in how it represents various areas. Lastly, I guess I would suggest the following, that number one, delay approving it. Number two, that we have a consultant come in and look at this who has actual coordination experience. From reading the minutes that were in the 31-page document, it was clear to me that we haven't had anybody with actual coordination experience. And again, I may be wrong, but that's what I got out of the minutes that were part of the document. And it might also be useful to, while that opportunity was there, and maybe we all missed it, which I agree I did, that we have some groups of constituents such as ranchers or industry sit down and hear about what this does for them. And then with that input, we could update it and have a more powerful document, because I think it's going to have a long-term use for the county, and it would be important to get it right, and a few more weeks wouldn't be that detrimental. Thank you.
Thank you, Mr. Foss. Anybody else wishing to speak on the non-agenda? Mr. Orlett and then Mr. Boyer.
My name is Don Roulette. I live at 16799 Highway 66, Ashland. This is serious business, which we all know. But I think somebody has to have standing when something needs to be defended about the economy of Jackson County. And I think that under the home rule that is the commissioners that have standing, if they are on record that the federal government must coordinate, not cooperate, coordinate, that's what the law says, so that we know what they're doing. And most of the time we don't know what they're doing. So I heard Mr. Jordan say that we need to make sure that we are informed about what they're doing. I want to take just a minute to give you a little background on just something that happened in our area, and it happened so fast that we didn't hardly know what was going on. But I think that what we're doing today is you're trying to make an attempt so that we can either slow down, stop, or do away with some of the things that are being proposed in our area. I think the most graphic example of what I'm talking about is the monument, the Cascade Siskiyou monument that was put into effect here just over 10 years ago. I am located inside the monument. And we heard about the monument it was about 3 weeks before it became law. Who in the world can react to something that major in 3 weeks? You can't do it. And even if we had reacted, we didn't have any standing as an individual or the county. But I can tell you, when that went into effect, things changed forever. Forever. Just for instance, the minute that went in, gates were put up. Probably hundreds of them that blocked roads, that blocked access, that blocked all different kinds of things. And then federal marshals policed it. In the first year it was open, there were over 30 arrests or citations that involved getting off the road into the monument. Hunters that had hunted up there for years and had a hunt camp or something. They could go on the road to get near the camp, but you get off the road, you get arrested. Arrested. Do you know that this year that over 10,000 acres are being put into the monument so that you no longer have taxes on it? Do we agree with that? It's gone. But more important, it's a lockdown of a monument and the proposed monuments. In fact, Mr. Obama, I'll call him Mr., but anyhow, he's proposing 8 million more acres to go into monuments, of which about 500,000 acres is right here in Southern Oregon. It's huge, but that land is locked up. Locked up. You can walk in there, but that's about all you can do. But those type of things affect this county seriously. Seriously. And I'm pretty pleased with the document that tries to spell out most of the things that would be involved in it. And I'm not a lawyer, I don't know that much about those things, but please get all the input in that you can so that, just as Ken pointed out, it's ahead of time that I think the offense is that you make them provide you the information so that you can react versus us trying to find it out. That's serious business. So with that, I think that you are a home rule. Like I say, that means that has a lot of weight. There's only 7 counties in Oregon that are home rule. Klamath County is not home rule. But he mentioned water, and I think that's really huge. I don't know if you saw the headlines over in Klamath Falls this Sunday. Adjudication confirms the tribe's water rights. Did you know that some of that water comes to Jackson County? Water, the dams that are being taken out over there, the energy, clean energy. So all I'm saying is this is really serious business, and we respect the 3 of you and know that you're our standing in this county for the things that make it economically viable. And everything, in 48% of the land in the county, 48%. It's huge. And I've just been 3 years, I accepted a buyout on my cattle rights. Well, there was a trade, 3 years, and it was a simple little trade. It's not done yet. They only wanted $80,000 to make a little trade.
Do you need to summarize? Go ahead.
I'm wrapped up.
Thank you, Don.
Thank you, Don.
Quick question. On this 5 pages, can I?
Yes.
Yes.
This was worked on up until midnight last night, and it's not complete. If we had a little more time, we would continue.
You'll be able to submit more material anytime. Mr. Boyer.
Commissioners, staff, members of the audience. My name is Charles Boyer. I live at 11630 Agate Road, Eagle Point, Oregon. I am also a member of the Jackson County Stockmen's, but I'm going to be speaking here as a citizen because I haven't necessarily got their vote as to what they want to actually do on this, but I think they probably, from looking at the audience, support what I'm going to say. Historically, I spent a career in the federal government with the BLM, and probably half of that I spent in the environmental and planning areas. And I can tell you that in my entire public career with BLM, I never once consulted with any local agency because they never asked for it. So what we did was what you got going on now, and I want to commend you for the actions that you're taking to get this consultation in progress and in place. I'd like to thank your staff and the NRAC committee who have put together at least the draft with your consultant of the policies that I've reviewed, and I think you're on the right track to get things done. This is a very, very important step. I think it's not only our right as local governments, your right as local leaders of local governments to do this. It is your duty to require this consultation process to be implemented and put into place and demand that the federal agencies comply as much as possible with local land use ordinances and planning. I've never done that, and like I said, in the entire career that I had, we would notify local agencies and governments of what we were proposing to do, but we never, ever did a real consultation. 5 years ago, a group of us approached this board different members, but this board asking for consultation to take place, and we certainly do. It's taken a long time, but I'm so pleased that you're where you're at, and please proceed post haste to get this into place. Get the advice from the people that you've heard earlier. I agree with some of the comments that some of this isn't as quite as detailed as it might be, but I would encourage you to get it in place and demand it's your rights. When it says in the act that the agencies will comply with local plans and ordinances as much as practical, what that really means is they have to have a federal law or mandate that they cannot comply with your plan. Not that the local agency head chooses not to. It means that the agency as a whole, from Washington on down, has to have either a law or some other type of federal mandate that precludes them from complying with the local law, the local ordinances, and the local plans. That gives you extreme leverage in this process. So once again, I'd like to thank you all. I'm going to have to leave. I have to go to another meeting, but I certainly do commend you for taking this action. Go with the coordination, none of this cooperation stuff, because that gives you nothing. Go with the coordination, go with it full bore, get it as strong as you can, and implement it. Thank you.
Thank you.
Okay. Mr. Miller?
My name is Bob Miller. I am a foreigner in one respect that I live in Hornbrook, California. However, I'm here to represent the Jackson County Cattlemen.
Your address in?
I'm in 14934 Hornbrook Road in Hornbrook, California. I'm the co-chairman of the Public Lands Committee for Jackson County Cattlemen, and we haven't had a meeting this month, but at any rate, I and Charlie co-chair this committee, and I'd like to make the statements. First, I very sincerely support the previous three speakers, especially Charlie when he said, Mr. Boyer, when he explained to you the fact that this is a legal situation and the agencies have to coordinate with you unless they can find a legal way that they don't have to. It's not whether they want to or not, and this is pretty well established. I'd like to give you just a little bit of history on coordination. There's one person that I feel is probably the biggest authority on coordination you have at your disposal, and I'd like to see you have him look your ordinance over before you finalize it, and that person is Fred Kelly Grant. He is a former U.S. district prosecutor at one time in his career. However, he came back home to Idaho in the early 90s to try to retire, and his father said, you've got to help these cattlemen out. They're our friends. You were raised with them. And the Owyhee County cattlemen were facing Mr. Babbitt, and he was going to make them poster child for cattle free by '93. And in essence, Owyhee County, Idaho is basically based on cattle grazing. That's their main economic base. It would have destroyed that county and their economic base had Babbitt enacted the restrictions he was trying to ram down their throats. Fred Kelly Grant went to, did some research, and that's when he found the coordination language in NEPA. He went to the BLM and said they had to coordinate, and they laughed at him. He went straight to the top in Washington, D.C., and BLM was told, you better come and talk to us. They set up county committees to deal with different issues. They gave these committees power to make recommendations to the county commissioners, and they whipped Babbitt on this thing. From that, Fred elaborated on this, and he's had numerous seminars and training sessions. He's still giving them, and I think you'll find he's a very well-versed authority on this process. The reason I mention this is too often I've seen a process started with all good intentions, and then somehow it was, especially if it gets to be too long and big like we're talking about here, possibly there's a loophole the government can come in around and circumvent your intentions. I think it'd be good for you to get an interpretation from him, or an opinion at least, of what he thinks of your ordinance before you pass it finally, because he's been through this with a number of counties. He helped stop the Trans-Texas corridor going through Texas, which was 3 football fields wide, going to go the full length of Texas, from Mexico to into Kansas City, Kansas, to a sovereign port. It was an internationally planned thing. At any rate, 4 mayors in Texas took this process and stopped it against Rick Perry's, a lot of pressure from Rick Perry and the Texas ODOT. That's just a couple of examples. So at any rate, I would ask you to really make sure you get all the T's crossed and the I's dotted before you adopt this thing, to make sure it does what you want. And it would, I'm sure you'll find it will help to sustain and increase the economic base of Jackson County, because we had seen too many cases. I hope you can use it for the proposed national monuments. They tried this in some cases. In some cases, they circumvented that with the presidential order. But try it if you can, because we need to stop that if at all possible. We need to keep the economic base of this county going so these people can survive in this county. And that isn't just the livestock industry. That's everybody, because we're all in this together. So at any rate, I'm going to, in essence, end with that, because I think these other people have very much covered it. And I compliment the board for getting to this point. I know it's been a long process getting here for the last 5-7 years. But thank you.
Thank you, Mr.
Thank you.
All right. Anybody else wishing to speak?
This gentleman stand
Paul
up.
Kangas. Oh, I'm sorry.
He stood up first.
I'll get that. Looks slow.
Paul Kangas. I live at 1421 Ramada in Medford. Charlie Boyer said something about what he thought the government did as far as coordination with the county, and I sort of agree with him. There's what the federal government has done in the past, and what they considered coordination with the government is really something like just providing information, and they come to the county and talk about what they plan on doing with the timber sale and so on. And after the timber sale has been all planned out, and their land use plans have been sort of the same thing. So what the planning process is already involved way along before the county knows anything about it. So that's the level that you will see when the government, the federal government, BLM, and the Forest Service discuss what they're doing and sort of solidifying what they say they're doing in coordination. And but what does the county expect? That's a whole different matter. And I'll read this. What should the county expect in its involvement with the federal agencies and the land it manages in the county? They expect information, early and detailed. They expect optimization of understanding between the federal agencies' plans and those of the county. And they also would expect implementation of the federal plans that optimizes the final decisions. There's a huge gap between those two issues, between what the federal government has thought they were doing to inform the counties and what they're doing, and what the county expects them to do. Let's see, my little notes here. I've got to read these notes. Example of sort of what Mr. Boyer said. I was involved in the development of the Northwest Forest Plan. I was in the Portland BLM office at the time. The basis for the Northwest Forest Plan was done in the early 90s, implemented in about 1995, and the basis for it was based on 5 people. It was called a Gang of 5. A few professors from organizations, colleges and so on, and they brought in government agency people to discuss things with them, but there was no coordination with with the counties on that. It was all developed on the basis of President Clinton's volition, of course, as you all know. Other things came along, the National Forest Management Act. I doubt if the county ever had any involvement in that other than possible information from the agencies. Of course, we heard people talk about the national monuments, and that's something that everyone is bothered by, the declaration of land to be set aside by the stroke of the president's pen. The Western Oregon Plan revision, as more recently as everyone knows, was a plan that the BLM had sort of as, it was to satisfy a lawsuit, actually, that the BLM wasn't putting enough timber on the market and so on. It was done sort of as to satisfy the lawsuit, so that they would be doing more than they would under the current plan. What they're doing, about 20% of their forest management requirements versus what was called for in the National Forest Management Plan. And of course, we know what happened to the Whopper. It's called the Whopper, the Western Oregon Plan revision. It went away in a political stroke. It didn't really go away, but it sort of did, because the BLM doesn't like it and no one else liked it. So it's basically gone. So those are some of the things. Now, what are some of the solutions that I consider could be help this matter? There could be many, and they could be legislative, they could be administrative, but they must have a couple of common themes in order to pass the people's choices. They must be sustainable and adaptive to natural and unforeseen change. Anything that isn't considered sustainable is probably not going to be very popular. And of course, when we speak of natural and unforeseen change, we talk about climate change and those sorts of things that could happen that has to be sustainable. So anything that we adopt has to be sort of sustainable and changeable. Whatever we adopt must be acceptable to the majority of the citizens while recognizing the concerns of others. The management of our forests and natural resources that need to be optimized, that sustain species, the environment, economics, and the needs of the people.
Is that your wrap?
No, I got one more point. The BLM, I just heard 3 days ago or so, they're entering into a new phase of planning, land use planning. And I don't know how long that'll take. It usually takes 5 to 10 years. So I think it's an opportune time for the county to modify its land use plan so that the new plans as developed by the BLM will have to incorporate the new plans of the county. If they aren't, where they should be. So, and they should, which would include a lot of the things that are in this coordination agreement. So I say pass coordination. Thanks.
Thanks, Paul. Ladies and gentlemen, in the interest, come forward, sir. In the interest, in the event that usually we don't allow outbursts in the middle of our hearings and so forth, because there's a lot of folks pro and con, and so we try to keep the atmosphere fairly neutral on the hearing process. But I thank you for your exuberance, but please refrain from that. There, sir, go ahead.
Good morning,
please identify your name and address for the record.
My name is Ron Gibson. I live at 2003 Stewart Avenue presently. I am the Vice President of the Southwest Oregon Mining Association. I am one of the initiators of the newly formed Jefferson Mining District. I want to give a little history on that, if I may, quickly, so that you understand where I'm coming from and the people that have asked me to come here today. The mining industry in particular, as well as ranchers and loggers and whatever, have been under attack for years, and with a very inadequate way of defense of that. I am a 44-year student of law. I went to school to become an engineer. I became that. My secondary studies was constitutional law, and then I got into mining law, contract law, etc. I am not an attorney. I don't want to be an attorney. But mining law, right-of-way, water rights and stuff that I have an extensive background in. And I say that not to promote me. That's not my point. I'm here today for the purpose of sharing with you in support, number one, of what you're trying to accomplish. The coordination process is long overdue, long overdue. There has been some extensive abuses relative to the federal government and the federal agencies in reference to the counties and their economic protection, if you please, and the open door of the county to run the county the way that it should be run and the people desire. Every county is different. And so those things have to be independently addressed, as you know as well as I do. But I want to share with you, first of all, a statement. I find the draft document severely flawed. And my point of that is simply that I see the word over and over in that of cooperation. I have attended on 2 separate occasions Fred Kelly Grant, and the rancher gentleman spoke of that earlier in testimony. And I have been through his seminars extensively. And I have a keen interest in that because I'm a former rancher. I'm the son of a rancher. I've owned my own ranch. I've been in the logging industry. And when you address the issue of coordination that is so important, gentlemen, you have a tremendous responsibility here. And that was stated before. And I want to encourage you in that not to rush into this. I think there are some serious things flawed that I want to give written documents to be entered into the record, if I may. But the fact of the matter is that in the mining industry, if I can digress to that just a second, and I have here well, I have it, believe it or not. It's called the Congressional Grant of 1866. And the Congressional Grant was a grant that was granted to the citizens of the United States, that the mineral was given to them. And that was done in the form of grant. It's called H.R. 365. And if you look at that, in 1870, they implemented the Placer Act, which included the alluvials, your river rock, that kind of stuff that was not hard rock. And then in 1872, they implemented the 1872 mining law, which stands today. And I study extensively on Supreme Court cases, et cetera, et cetera. And one of the things, to digress a moment about the logging and the industry, and I've been involved in that business for years. In the case of New Mexico versus the United States, the Supreme Court stated equivocally again that the national forests were created for the production and the sustained yield of timber. That was not to be altered by any other enactments. It was to sustain the timber yield, and it also for the free flow of water for the counties and the ranchers and industry, et cetera, et cetera. That has been tremendously infringed upon, and they're trying to tear 3 dams out down on the Klamath River. I attended those meetings, and there's a great merit to the arguments against that. I would like to enter into the record, if I may, H.R. 365 for your review, if you may. Also, I would like to introduce to the record, I have worked myself and several other people with Josephine County and the coordination issue, and with Sheriff Gilbert, who's a counterpart to what you used to be when you were sheriff here. Sheriff Gilbertson, we approached him about the abuse that...
Do you want to summarize, though, and go ahead?
Okay. Yeah. Basically, what I'm saying is that this coordination thing, I don't think there's anything you gentlemen will do that's more important than what we're talking about here on this coordination. And I would encourage you, please make sure that your item. There are issues of law here that are not adequately addressed in that this document, and I could go on, but I have some documents that I would like to...
If you could present that to the young lady over there. So thank you very much, sir.
Thank you.
All right. There was another gentleman wishing to speak here.
Morning. My name is Jim Lutter, 3775 Coleman Creek. Yeah, 3775 Coleman Creek Road, Medford. Thanks for having the meeting. I'm just here because I'm happy. This is one of the, I just found out about this recently, and this is one of the neatest things I've heard about in years, to get some local control into things. I'm here, there's 3 points that, that I saw in reading through this that I just wanted clarification or reconsideration of, and this might be more from the on the legal end. I'm not an attorney, but just a couple things jumped out at me. On page 2, right above, in the middle, right above point B, right above that, the last sentence says, the federal agency should also seek consistency between the proposed action and Jackson County laws and plans. I want to know, is it should or must? Because without, okay, that's, I take it that's been addressed before from the look over there. I had a question or concern towards the end of the document, page 13, B1 energy generation, and the wording is expand access to low-cost power for consumers. And my thought there was just to not be hung on our own words. If you know, sometimes you can get stick your neck out with your wording. There may be a point in time where it's not a matter of low-cost power, but just getting power. And I would point out our current president has specifically said if we were to implement his energy policies, it would necessarily raise the price of energy. And I think the people that are in ways dependent upon the power produced by the dams on the Klamath River, they may be happy to get, I mean, I'm sure they'll get energy, but they may be happy to get it whether it's higher or lower. I can't imagine it going lower when you're removing dams. But the last question that I had as far as giving teeth to this, in the going through the act, a gentleman earlier eloquently expressed the idea of making sure that the feds cannot deny something, you know, unless they've got strong law behind them. So my question, and pardon me if this has been addressed, but I don't understand it here. Can the feds trump or negate a local decision merely by an administrator writing just a rule, you know, something that has not passed through Congress as an actual law? So that is something that, forgive me if it's been addressed, but this was my concern. Thanks for listening to me. And I really appreciate you guys doing this. I think this is wonderful. I'm really happy about it. Thanks.
Thank you. Don?
Don Ellsworth, 3303 North Valley View Road, Ashland. I'm just like you. I knew exactly where I was on December 7th, 1941. So that tells you that I'm probably must be almost 100 years old. In any event, this is something that you people are doing that I'm really grateful for, and I really have an opportunity to be here with you is a privilege we have of this country we live in, and so not being the scholarly type, I went back and looked at the Constitution, and everybody kept saying, well, I'm not sure about this. I don't think that the federal government, the way I've been reading it the last couple of days. I've run over it, and I went back again, and I read it, and then I looked at some people who wrote dissertations relative to the Constitution. And I'll tell you what, the federal government doesn't own this land. They can't dictate to us what they can do and what they can't do. We own the land. They have stewardship, I would agree, but when they make some of these plans, like taking the dams out, for example, you know, like with the federal mandates that they're putting on it, that's they should be coming to us and talking to us about it. You shouldn't have, you know, Danny was talking about, well, we could pick up the phone and call them when we see something they're doing. They should be calling you and saying, hey, we've got this project going, what do you think? They got it backwards as far as I'm concerned. We're the people that live here, and they do not own the land. And that's the way I read this. I think, what is it, something like about military installations and nothing bigger than 10 acres? I wrote a letter to the Mail Tribune about this very thing, about are the ranchers and the farmers going down the same road as the loggers and the sawmills? And they sent my letter back and said, well, it was too long. So I revised it and I sent it back to them. They sent it back to me again and said, well, you're still over the 200-word limit. So I sent it back again. Then I got another. At the third time I got it back, they said, your letter's unacceptable because it's inaccurate. There will be there's no, nothing on irrigation that will affect the Rogue Valley. So again, I wrote him a letter back, and I sent documents that I had kept in with some of the stuff that I've been picking up on removing the dams. And I never heard from him again, needless to say. And I sent the whole package to the Capitol Press, and they put it in the paper. Does that tell you something about the media? So we're being brainwashed to a point. And I keep hearing everybody talk about, well, we have to, the federal government does this. They don't own the land. We're the people who should be stewards of the land, and they should be doing it at our direction, not dictating to us like taking like this stuff about taking the dams out. The environmental zealots are getting after us, and I'll tell you what, this Agenda 21's on the road, and you better take a look at it and see what they're trying to do, because you can see it going right up their alley. That's exactly what they want. And we need to be conscious of it. And thank you for this coordination program. We appreciate it.
Thank you.
I need it lower.
Okay.
My name is Sandra Schmitz, SCHMITZ, 10 East South Stage Road. And I'm also want to commend the commission for starting the coordination process. And I think citizens as well as local governments need a little more education and planning of this process. I understand it to be the process of government-to-government coordination consistent with social, economic, and political customs of this county, of counties, and other government entities. And the federal government is to coordinate with us, not them come in here, the state and federal government come to us and say, jump, and we say, how high? And we want this done, and how soon can we get it done for you? They are to come to the table with us and provide all scientific and economic peer-reviewed research in order to have complete studies on everything that they propose to us. And as citizens become more and more aware of this process, they will demand that local officials exercise their rights of sovereignty. Thank you.
Thank you, Senator.
Good morning.
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 My name is Tom Steen, and I am a resident of Medford, Oregon. It's S-T-E-E-N. My address is 701 Western Avenue. Like many others, I'm deeply concerned about the increasing intrusions by the federal government into the affairs of state and local governmental entities in matters which affect local communities in various ways. And I agree with other speakers who are recommending and requesting a delay of action on ordinance number 2011-15 until various questions and conflicts are resolved. Those questions may include, for example, is it in fact necessary that the county excuse me, that the county negotiate formal coordination procedure agreements with individual federal agencies as noted in section 1231.01 subsection B. Is such an agreement legally binding on the county? Is such an agreement legally binding on the federal agencies? Is such an agreement necessary in the presence of the county's established right to coordination with federal agencies in regard to proposed federal actions which may affect the economic, social, and political customs of the county and its citizens? This proposed ordinance appears to be a commitment on the part of Jackson County to certain policies without any matching commitment on the part of the other party, namely the federal agency. These and other questions need to be carefully reviewed by representatives of property owners, voters, and other citizens of Jackson County. I thank you for this opportunity to speak to you, and I hope that you will consider a reasonable delay in your action in order to more fully clarify the risks and rewards of pursuing and adopting the proposed ordinance and its related agreements with federal agencies. Thank you.
Thank you.
Thanks, Tom.
Anybody else wishing to speak? Okay.
Lynn Horstemeyer, 330 Conestoga Circle, Jacksonville, Oregon. I have seen what happened during the Cascade-Siskiyou National Monument. And there was a lot of consultation done with like K.S. Wild, and they actually worked, the federal government worked in conjunction with them. And I see the same thing basically happening again with the new one, the Siskiyou Crest National Monument. They have been working for years. In fact, ever since the Cascade-Siskiyou National Monument, when that was cut down in size, K.S. Wild had wanted to take it all the way to the ocean. It was even in the National Geographic magazine in August of that year that they wanted to take it all the way to the ocean. And they've been working, and over the last 10 years, they haven't pushed it. You haven't heard much about it, but now you have a different group in charge, and all of a sudden, you're going to hear about it. And I'll tell you, if it looks like Obama's not going to win, or if he doesn't win this election, by the end of 2012, you're going to see it be made into a national monument, because that's exactly what Babbitt did before. It was at the very end of the Clinton administration. So coordination is very, very important. And why aren't they consulting with the county long before a president comes along and says, it's done? So we need to be sure that we are well aware of what's going on. And I know that we haven't really worked hard enough on getting the actual information about how those dams are going to affect the TID and other areas. That needs to be really looked into. And I'm glad you're going to be starting to do something on this order, and good luck, and may we have a really strongly representing our county. Thank you.
Thanks, Lynn.
Hi, good morning. My name is Jerry Carsey. I live at 880 Cambridge Way in Ashland, and I'm a realtor. And I would just like to say that, I also stress the importance of this. If the dams come out and we actually experience a significant drop in water to this valley, and as a realtor, I'm selling real estate with irrigation rights. I think that myself, or my fellow realtors, and my future clients have a right to know whether or not in 3 to 5 years they're actually going to they're actually going to enjoy those irrigation rights. So this is a huge impact, and obviously I'm not here to reiterate the importance of all this. I think you understand that. You stand as a firewall between the federal government and ourselves and as citizens, and so I understand that, I get that you understand the importance of that. I think everyone in this room understands the importance of that. But it's not just what you do, I think it's how you do it. And that's what we're trying to say today, is that I hear over and over and over again from people, it's how you do it. I understand that you can make amendments to this thing after it's adopted, but I'm sorry, I don't have a lot of faith in that. There is just, quite frankly, too much at stake. We need to put our very best foot forward. There needs to be more teeth in this. And maybe it's because I come from Ashland, but I would like to discuss the spirit behind this. I think it comes from your belief system. We saw in the paper that, the federal government, we're just kind of here, hoping that they just kind of cooperate with us. And that general attitude is after many, many years of being beaten down. I mean, the gentleman here testified that the BLM never coordinated. This is all a brand new thing, even though they've been required to do this for a very, very long time. But they have all the money behind them, and they have enough arrogance behind them to just bowl right over us, that over and over and over again. And so what I want to know is, what is your belief system? I mean, Mr. Jordan here is saying that the federal government owns. He used the word own, and you see what kind of reaction that got. First of all, the gentleman's right. We are the federal government, and we own. We, the people, own. So yes. So the question is that what is the spirit behind all this? I mean, I'm kind of a newcomer to this, but I'm finding that there are people that disagree with that the federal jurisdiction does not overrule a local or a state jurisdiction, that this jurisdiction over this land is concurrent. It's concurrent jurisdiction. So if it's not, let us know that. If we're just the underdog here and hoping that they coordinate with us or that they cooperate with us, let us know that. I would like to know what your belief system is, because from that, I believe everything is generated from that. Not if you proceed, because we all agree that this is long overdue and that this is vitally important. We all agree on that. But I want to know how you're going to proceed, and if you're going to take the concerns of the citizens in this room seriously and consider that we absolutely consult like Mr. Kelly or people who have enormous amounts of experience with this. Having some experience, to me, is quite frightening. I want the best for this county, and I believe that the citizens of Jackson County deserve that. So in conclusion, I would just like to say that we, the people, would like to see you reconsider and make sure that this goes back to the drawing board and make sure that what we come out with has teeth and truly protects the people of Jackson County. Thank you very much. And I do appreciate, I know I'm very intense, but I do appreciate the fact that you're doing this, and I really and would like to cooperate in any way that I can, but this is too important. Thank you.
Anybody else now? Yes, ma'am.
My name is Beverly Layer, and I live at 2341 Jean Cameron Way here in Medford. And I am also a member of Americans for Prosperity. And I have become interested in coordination since about last summer. I wasn't aware of it before. And I appreciate the opportunity to talk to you today. Thank you for that. And I think it's wonderful that you are bringing this to our county. I applaud you for your study and your efforts. We are so lucky to have you doing this. It's a great tool, and it gives a lot of weight to the way that we live here. And I'm also glad to hear someone stated that going into this process is also a learning tool for all of us, including you as you're going into it. I have two concerns, and one of them is, I guess, the attitude that a couple of people have mentioned, I think, before me about the attitude that maybe is being spread by our press toward this process. And then my other concern is a little bit about the document itself. And I just want to mention the most recent editorial that was in the paper where it talked about if there's a clash between the federal and the local, most likely the federal would win. I really think that local governments who have applied coordination would disagree with that statement that was made. And it's been in use for 21 years since it was found embedded in many, many laws, and it has been very successful. It has supported small communities across the nation, with Owyhee County in Idaho being the first one. The same editorial indicated that local officials are already given the opportunity to give communication and input, but coordination is way more than just being allowed to offer your communication and input. It puts us local governing boards on an equal footing with federal agencies. And as it's described, the word coordination in Webster's dictionary, it says it's operating as a party of equal importance, rank, or degree, not subordinate. And that's the definition that the courts have upheld with this. It's a strong, powerful tool to use. And that's the attitude that needs to be shared with all the people in Jackson County. And those in position to bring this about for us need to protect us well and choose this document from that standpoint of power. Jackson County is also in a position of influence, being the first county to have come this far with coordination in Oregon. And I think that not only do we need to protect ourselves with a very strong document, we need to set a good precedent for the state of Oregon in how this is put forth, because we are all interconnected. Our federal government asserts itself very well to us. We all experience that. We feel it every day of our lives. And they own well over the, almost half of the, well, own, they manage almost half of the, or sort of manage, the land in our county. But we, on the other part of the land in the county, have a history that's social and cultural as well as economic and environmental. And all of this needs to be in place, and Jackson County needs to help us achieve the right balance of all those parts. The federal government's not going to help us achieve balance here. It's up to us, and we depend on you. Our coordination document is our time to express who we are, as the federal government has done so before us. I believe that who we are and what we intend should be often and strongly stated in the document. I have a few concerns about some of the wording in the document, and I too would appreciate if a little more time was taken to work on the document and make it as strong as we possibly can make it. And I do believe that to have it reviewed by someone who has had extensive experience working with such things would be a very wise thing for us to do. We need both the strongest document possible, and we need an attitude of determination and support in it that will match the strength of our document. Thank you.
Thank you. Thanks, Bev.
Next. Good morning. My name is Kathy Lehman. I live at 807 Wrighton Drive in Ashland. I applaud your expressed intent to coordinate. I don't believe most people understand that everything we need just for our basic survival, food, shelter, and clothing items, must be either farmed or mined. That bears repeating and demands serious consideration and an immediate course correction, because we're in trouble in this county, as is most of the nation. Fred Kelly Grant is counsel and lead negotiator for the Trademark America Institute. Fred is widely acknowledged as the father of coordination, especially by the Department of Justice, who has repeatedly had to remind federal agencies of their congressional obligation. Fred conducted his first national training seminar in our area in February of 2007. Arrangements were made so that every interested county employee could attend this two-day event with the training fee paid privately. This invitation extended to the Board of Commissioners was declined, and that's unfortunate. It was a golden opportunity lost. Fred Grant has now taught coordination all over this nation. The first county he taught has now been successfully coordinating to the benefit of its citizenry for 20 years. There are now well over 100 coordinating counties, cities, and special districts. Another golden opportunity lost was when the board chose not to hire Fred to consult on coordination during last fall's RFP process, choosing instead firms specializing in environmental law with no track record and, as you were made aware, no knowledge of the coordination process. I have studied coordination and worked with Fred almost 5 years now. I am a senior fellow with Trademark America. I have taught, advised, and consulted with citizens groups, special district boards, and county commissioners, supervisors, and sheriffs in California, Oregon, and Washington. I have reviewed this proposed ordinance and tell you emphatically this is not a plan to coordinate. I know coordination, and this is not it. I worked for the Forest Service for 7 years, and I can tell you that nothing in this document will bring them to the table to coordinate. County ordinances control county residents, you and me and everyone in this room. They do not control the federal government, as they will tell you immediately and cite the Supremacy Clause. Unfortunately, there isn't even a requirement in this proposed ordinance mandating that this board coordinate. Merely expressing your desire to do so and citing a variety of policy and statutory language, which is unnecessary and might be better expressed in a resolution if you don't intend to have any teeth in this ordinance. And I'm not saying that to you personally because I know you didn't write it. I will not address coordination in much detail here. I've brought copies of a white paper on the process for your later perusal, but I will tell you that a written plan is not required to coordinate effectively. If a formal written plan is produced, it should always be marked interim draft. A formal plan can lock the local government into a position, denying it flexibility it may want later on. I cannot say whether this proposal was written by those who still do not understand coordination, or perhaps who intend to establish cooperative agency status for the county at a later date, which is where it seems headed. That would be counterproductive, cost the county resources, time, money, and would give the feds extra jurisdictional authority over the county they now lack. And they know that. Congress defines the land management tasks it relegates to the federal resource agencies through such acts as the National Environmental Policy Act, Federal Land Policy Management Act, the Endangered Species Act, etc. These acts do not all contain the exact same coordination language, but the laws of legislative construction state that unless Congress specifies otherwise, all laws of a similar subject, such as resource management, must be considered in pari materia, as they have a common purpose. The Supreme Court ruled in 2007, for instance, that the ESA does not trump acts such as the Clean Water Act. It depends on whether a particular act gives the agency discretion to consider the ESA. This is why the ESA may not lawfully be employed to halt logging conducted under the ONC Act. And the ONC Act requires sustained timber harvest sufficient to produce vibrant economic health, not sustainable harvest. We've been led astray very, very seriously. This coordination proposal completely undermines the coordination process, and if followed as written, the federal government agencies will have the power to ensure this board never does coordinate. The agreements here proposed will allow the agency to lower its treatment of the board down from an equal government-to-government relationship to that the general public receives. That is, the agencies must listen to us, but they are not required to consider, let alone act on, our concerns. Which begs one question in closing. Board Order 186-10 instructs the counties, NRAC, and others to prepare a coordination plan, quote, that would protect and enhance Jackson County's economy while promoting the responsible employment of resources on and in the federal lands, unquote. That struck me as an odd word to use. I was taught by Mr. Grant that words have meaning. The dictionary defines employment as, quote, that which consumes time or attention, unquote. So I'd like to know, why wasn't language such as responsible harvest and extraction chosen instead? If the board sincerely wishes to coordinate successfully and beneficially, and I pray God you do, this proposal must be significantly modified, starting with the complete removal of sections 1231, 01, and 02. I hope you correct this document over the coming weeks so you may work to the benefit of the people of Jackson County and our nation. And I thank you sincerely for your attention and consideration.
Thank you. Anybody else wishing to speak about this issue? Anybody else wishing to speak? Everybody felt they got their time in to speak? Okay. With that said, I'll close this portion of the public hearing, and staff has prepared a series of responses in some of the questions you've brought up, and we may be able to answer a lot of questions in some of your questions you bring up. So with that said, Ryan, do you want to go first, or Danny, you want to go first? All right. Yeah,
I'll go first, Mr. Chair. First of all, I'm going to try to speak to process issues and stay away from the political issues that you guys get to deal with. And if I cross the line there, I'll apologize right up front. First of all, I don't necessarily disagree with Ms. Lehman that this isn't a plan. In fact, the ordinance says it's a policy. And one thing I tried to explain when I expressed a summary of what we're trying to do here was that that didn't include every detail. But for purpose of the public, this is part of the process to get to a plan. Even if you pass this ordinance, we're not in a position to demand coordination yet. There are many steps in this process. Now, I'm not the coordination expert. I'm repeating the same thing that you were told by both county council and our external counsel in terms of the process steps they recommend we should go through. My assumption is there's probably a lot of different ways that you could go about this, but this is how you've been advised, so that's what I'm repeating here. First of all, over a year ago, the board did pass a resolution demanding coordination. The issue of developing this policy was at the recommendation of council so that you had a broad policy that you could present, which is the next step after you pass an ordinance, in notification to the agencies that you've both passed a resolution and that you've adopted a policy requiring a process for coordination. That's the part where one of the speakers spoke through to negotiating that process. One of the things that I heard today was that the policy doesn't include enough positions on specific issues. And so that the public understands why the policy was the way that it was, in the advice of council, you were asked to leave the policy open and flexible because the positions on policies change depending on who's sitting in these seats. And one of the examples cited was, timber harvest. Now, I'm not saying this is the position, but you could get 3 commissioners up here that get elected by the county who decide they don't support that. But that doesn't still mean that we would want to have a policy demanding coordination. But what it does is it allows flexibility after the policy for whoever's elected here by all of the people that are here electing you to present your policy decision. One thing that is essential in this process is that the county does provide the agencies their policy position. The reason why it's not in the document is because over time, first of all, we can't predict every position we would take on a policy, on an issue that may come before you. Secondly, those positions may change. But in support of what I'm hearing here, as I don't really disagree with anything that I've heard, but process-wise, there's other steps to implement most of what has been presented here to you. I won't argue the legal piece. I'll let Ryan speak to that in a second. One thing that I heard today that I want to correct is it's been stated several times that the federal government's been required to coordinate with us for forever. And that's true to the extent that the county can't just expect, and this is based on, once again, the legal information that was provided to you and me, the county can't just sit back and expect it. There's certain responsibilities upon the county. The federal government is required to coordinate so long as we demand it. And there's a process by which you go about demanding it, and we're in the steps of that process. And so the expectation that they should have done this before would not be a legally binding expectation. It might be a reasonable expectation on people that they should do that. We're moving to the required to do that phase. And it is incumbent on the county to do the things we did, pass the order saying that you demand that. Secondly, have a policy that's at the direction of council. Thirdly, notify the agencies in writing, copy them with the policy, demand a process for negotiating how coordination will be affected between the agency and the county, and then move forward from there. And I've heard lots of people ask you to suspend this. At the same time, I've heard a lot of people express concerns about activities that are going on right now with the federal government that they would like you to intervene on. We've been 1.5 to 2 years to this process. Every meeting that's been held has been open to the public. There have been public hearings through NRAC. We've had a consultant. You've probably discussed this, I would say, 3, 4, 5 times in work sessions, and the previous board discussed it in work sessions. I'm not dismissing the fact that there was a lot of good input given to you here today. However, what I'm suggesting to you is, remember, this ordinance won't go into effect till February, even if you do pass it today. And even when the ordinance is in effect, our right to coordinate, to demand to be coordinated with, still isn't effected until we go through those other steps. So we're probably talking a year, 6 months to a year at least down the road before you actually get to coordination. So I might suggest an alternative route for your consideration, and that would be to pass the ordinance. And if you heard things here today, and the reason why I'm saying to pass the ordinance is based on input from county council, your external counsel, and the consultant, there's nothing that they feel creates a liability here for you. There may be members of the public here that feel that, but I'm telling you what the people you hired have said. In this case, what I think might be a better route, because we can't intervene and demand coordination on any of these issues that were presented today. I heard Klamath Dams, I heard national monuments, I heard, multiple things, till we get through this whole process. So I might suggest you consider adopting the policy. However, if there were things you heard today that may affect change, and there's people you want to be involved in the process of making those changes that were here today, you invite them to the table while this ordinance is going through the process. You can adopt a new ordinance, and you can do it as an emergency ordinance if it's something that you feel needs to be changed right away based on the input you have. But by not adopting it, we're not having any place at the table. Mr. Chair, and I know Ryan has some responses to some of the legal questions that you were asked.
Danny, question from
Just a second,
Commissioner
please. Would you for me delineate? You talked about other steps, and then you used the term, could be a year. Could you tell me what those might be?
What's that? Yeah, basically providing notice to the agencies that you've passed this policy, that you've demanded your right to coordinate, to negotiate a formal agreement for coordination.
Right.
And those are things that take time. And negotiating an agreement, depending on how an agency wants to work with you, and my guess is the board will direct staff to make sure that agreement contains all of the rights that you're afforded under coordination. Depending on how an agency responds to that, they could fight you on it. I'm not saying they will, but they could. And so that's why I said 6 months to a year from today. 6 months, The reason why I say 6 months is 60 days from today, we can't even do anything till, assuming you pass the ordinance today, because the ordinance doesn't go into effect for 60 days. So there's 2 of the 6 months. So I'm giving myself at least 4 months to put them on notice, give them the opportunity to respond, require them to develop a formal plan with us, and then move forward.
Okay, well, forgive me, but I don't understand the point that we have to. I understand the 60 days for the ordinance to get through the process, I think, but what I don't understand is that I thought I was told that by law there are coordination requirements in federal statutes. And I know it's stricter for like BLM under a particular act than it is for the Forest Service and a couple of the other agencies. However, that's already on the books, as I understand it. So I guess. I'm just confused why we think it would take that long. I mean, if we pass this ordinance and the ordinance creates a codified, it's codified as a county ordinance. Okay, so.
And I think your speaker was right with regard to that. That does just affect county citizens. It doesn't affect the federal government.
No, I understand that, but I guess I guess I said that too many times. I am confused, though, as to the length why it would take this long to get it moving along, if we should enact the ordinance today.
Well, you actually would approve the ordinance. It wouldn't be enacted for 60 days.
Okay, approve the ordinance today.
Well, yeah. I'll let Ryan speak to it, but basically what happens is when it gets to that point of the ordinance being enacted, it's more enforceable. That's all it does. That's what that does for us. The meat is basically what one of your speakers said. This is not a coordination plan. The plan, the formal plan, comes in negotiation with the agency. Now, we can demand to coordinate on any issue. We don't have to have a policy. When we demand to coordinate with an agency on a specific issue, then there's certain things that the county's required to do. We're required to provide them what is our policy decision, what are our plans, what have we done regarding the issues that might impact us that the agency is working on. And the formal plan that we negotiate with them once we have standing, and when I say have standing, we've always had standing. What you're doing is making your standing more enforceable. Once we reach that area, then we negotiate with them how we'll proceed on issues that you may choose to demand your right to coordinate on. Because what you didn't do in this policy is say, hey, federal government, you're required to coordinate with us on every single thing you do in our county. I mean, you could have done that. Enforcing that would be pretty difficult, and I'll give you an example as to why. At any given time, the state may be working on, multiple, or the county or city may be working on multiple road projects that impact and require a NEPA evaluation. Does the county really want to be notified on every NEPA evaluation and be demanded to be coordinated on or not? And there's lots of federal activities that go on in our county that may not rise to the level that you choose to be coordinated on. You may want to be coordinated on every single thing. But those are things that happen with the negotiation of a formal plan. That's why I'm saying there's more steps left in this process. Now, I'm not saying this is, just so you understand, this is based on the input that I've got from legal counsel and our consultant. This is not my personal knowledge. And to say that this is the only way to do it would be improper. To say that this is the best way to do it is improper. One, because it's not been done frequently. As someone mentioned, we are the first county in our state to do this. And although there's 100 or so counties, cities, and jurisdictions that have this, that's really just a handful that actually exist out there. So there's not, and when we studied the way different jurisdictions did this, they did it differently. Not all of them, but some of them did it differently. So, the input I think you got today is great input, and I do think you should consider it, and I do think there's some opportunities to make improvements before what's placed before you today, should you decide to direct staff to facilitate that. But I also have a concern that putting off making a decision, at least getting us standing at the table, means that all of these issues going on, we're not going to be able to do anything about until you actually exercise your right to coordinate.
Can I ask counsel a question?
Yeah. Ryan?
Yes, sir.
So following up on Danny's, so if in fact we were to approve this ordinance today, from a legal standpoint, okay, does it impede us in any way? Is there anything that would encumber us further on down the road, just from a legal standpoint?
No, the short answer is no. We don't believe so. This coordination, right? And I'll explain this when I and very briefly go through some of the individual comments that were made for the board's benefit and clarification. But the right to coordination is given to the local governments by Congress. It's not created in the U.S. Constitution. It's not created in our charter. It's created by Congress. That right exists because it's written in the statute, and it exists from the time it was put into statute through today and beyond until it's amended. There are ways to get the benefit of that right that's afforded to the local government, and enacting this policy is one of the steps in that direction. Going from having the right to coordination just arising from the statute to having a formal policy that's enacted at the local level is an advancement with respect to how the extent of our ability to enforce that right. Enacted and then subsequently having agreements is the same thing. It just continues to become more and more enforceable. So I wouldn't, we don't believe that enacting this ordinance as written impedes our ability to utilize the rights afforded to us by Congress.
Ryan, any other questions of Ryan before? Ryan's going to give us a summation too on some of the questions raised. Did you have any questions, Ryan? Ryan, do you want to go ahead and give us a summation on some of the questions raised?
Yes, happy to. And I'll try to be brief. And to follow along with what I believe Ms. Schmidt had made a comment about, maybe I've got the names mixed up. The spirit of this is important, but since that is inherently tied in with the political realm of all of this, I'll endeavor to try to keep my comments limited to a legal perspective for your benefit. The first thing, I believe it was Mr. Fawson, wanted to add revisions to this ordinance so that it would be more specific. To follow along, I think Danny had commented on this to clarify the issue, that the policy is designed to be flexible. The county's, quote, plan can and should be expressed in particular when the federal agencies begin to coordinate with the county. Because there are an infinite and hugely numerous, in other words, number of federal actions that take place at any given moment and at the same time of all differing sizes in significance and importance, a one-size-fits-all coordination plan just is not workable from a legal perspective because it's difficult to write it in any way that makes it easy to enforce. And so it's designed in a general way so that it's more flexible. And that's also in response to any questions you have with respect to what Mr. Boyer said, because similar concerns that both of them raised. Now, Mr. Roulette, I believe, and again, we appreciate all of your very thoughtful input and comments, and this is offered to help put all this in perspective. And I believe Mr. Roulette, albeit enthusiastic about the effort to do this, was concerned that it needs to be upgraded to be more enforceable and to ask more of the feds based on home rule authority. Now, this is just a matter of governance and constitutional law, but home rule is not applicable to the federal land. The powers given to the county to have home rule authority is a power that's given by the state of Oregon, not Congress. And that home rule authority does not extend to matters that take place on federal lands. The federal government's authority to own the land, which it does pursuant to the U.S. Constitution, and to manage the land pursuant to Article 2, Section 9 of the Constitution, is something that home rule cannot interfere with. The reason that the county has authority in this instance to demand coordination is because Congress has said that the county can do that. It's not because of our home rule authority. So hopefully that helps clarify. It's a commonly misunderstood jurisdictional concept, but hopefully what I explained puts that all in place. Now, to go along with that, coordination doesn't really mean that the feds have to comply with what we say they need to comply with. Coordination just means that they have to confer with us and try as best they can to comply with our interests. There's nothing in the federal statutes, the various federal statutes that create coordination rights to various degrees, whether it's water matters, air, BLM, national monumenting, and so on. There are no coordination rights that are established that require the federal government to comply with whatever we say. It only forces the federal government to confer with us. And it's a little bit gray about to what extent they need to confer, but the more that we have in terms of official policy, i.e. a legislative matter, and individual policies created internally, pardon me, the distinction between owning the land and governing the land by the federal government, again, and I don't want to beat a dead horse, but just because this distinction is really important, I think, for the benefit of the board's deliberation. The federal government owns federal land pursuant to the Constitution. The duty to manage that land is also in the Constitution. Article 2, Section 9, Congress gets enumerated authority over federal lands. It's the only instance in which the federal government has police powers. It's a very bright line between the authority over federal land and the authority over local land. And so we can't force compliance with much. We can force consultation, and I hate to say cooperation, as I don't want to spark a political debate, but it can force cooperation. It can't force much more than that. So, Mr. Steen also asked about negotiating these subsequent agreements on coordination and whether or not those would be enforceable. Those are very good questions. All of these are very good questions and comments, and hopefully this is helpful. Nothing is necessary from a legal perspective. From a political perspective, it may be. The agreements that can be negotiated after this ordinance that are contemplated in the text therein would further the enforceability and add teeth to what is trying to be accomplished here. The other question about whether they are legally binding, by definition, a contract is an agreement that is, legally enforceable, and it's hard to say at the front end whether any contract that could be drafted is enforceable. We believe the contract that we have in mind that we would propose to enter into with these various federal agencies would be enforceable. But until that document is written and negotiated and penciled out, I can't comment on whether any particular agreement would be enforceable. But I could tell you the reason that this section of the ordinance that calls for entering into these types of agreements is because they are surely anticipated to be enforceable when that happens. I apologize if I've butchered anybody's last name, but it was Miss Horstemeyer. Her comments, I think I've covered. A lot of the comments that were made had common denominators or were echoing the comments that were made before that. So I'm just going to assume that I've covered those comments that were made. And the same would go for Ms. Layer and Ms. Carsey. Finally, and just one other point of clarification that I hope is beneficial to your deliberation. There's been a lot of comments about how complex federal law is and how many different statutes governing various different natural interests, whether it's species or water or air, and comments about the lack of any federal statutes that represent the interests of the people and the local governments. And that is arguably true, and the coordination effort is designed to put all that complexity funneled down into a general policy that requires coordination between the local government and the various federal agencies. It's another reason why this is not as specific as some may think it can be, because it's the only point at which we can reach a one-size-fits-all model to effectuate this coordination effort. I don't think, there were also, and one last thing, there were comments made about the Endangered Species Act and whether it trumps the Clean Water Act and vice versa, and interpretation of a Supreme Court decision that dealt with that issue, among other things. I don't know that it's necessary for me to comment on whether or not it's true that the court found that the ultimate issue is whether the decision is discretionary or not, but that's something that we could take up one-on-one if we need to later on. That's all I have in terms of responding to the individual questions, and hopefully that makes sense, but I'm happy to answer any others that you may have.
I have a question. Oh, go ahead.
No. Then I'll be quiet. The point was made 2 or 3 different times about when the process begins and we have an issue with say we move and it does move forward and they are actually calling us and it's an issue where we don't like it and they could say, well, we're going to do it anyway administratively. The point was made that they have to by law state that they can do that. I need a little clarification on that.
That's a very good question. That, I'm afraid, is not necessarily true from a legal perspective in every case. There's numerous coordination, there are numerous statutes, each with their own coordination provisions. And they vary to some degree, but I'm not familiar with any coordination statute that has been interpreted or written in a way that suggests that the federal action cannot go forward through coordination and passed without compliance with the local policies or some preempting administrative order from the president's office or regulatory measure from an administrative agency. The short answer would be I don't believe that's the case. I don't believe that coordination stops the federal agency unless and until they can show that they're not able to comply.
But let's do clarify that doesn't mean that they won't try. The federal agency won't try to do that.
And it doesn't mean that the efforts won't be made to persuade them otherwise.
Okay, thank you, Mr. Chair.
You have a question?
I have a couple questions. If we pass this and then we have amendments, if we pass this, we hammer out all of our agreements with the agencies, and then we have amendments, do we have to go back out and re-hammer out a new agreement with the agencies because we've now changed what we agreed to the first time?
It would depend on the situation, depending on the nature of the agreement. If it's an environmental issue and the amendments are concerning something that doesn't either cross paths with that or overlap, perhaps you wouldn't need to, but if you did, it would be through an amendment to the existing agreements subsequent to an amendment to the ordinance.
And I was thinking of fairly simple things. If we added in there some wording that wasn't it, we add it later as an amendment, such as they needed to take into consideration our social and cultural aspects, would that require us going back to the table? I wouldn't think so.
No, it wouldn't. It wouldn't require us to go back to the table. In fact, the agreements could be drafted in a way that contemplate those subsequent possible changes.
Okay. And
they could be added as amendments.
Yes. And if I understand this right, the issue out in Idaho, I believe the BLM decided they wanted to count the cattle off of the Oahe County, and then the local, say the local county said, because they thought the cattle were rooting the ground. So the local, let's assume it was the county commissioner, said, no, we don't believe that. Whose burden of proof? Who has responsibility there? The federal government or the county? I understood that the federal government then took the information that was provided. And so who pays for that? If there's a study that needs to be done, or is that the way that process works?
Oh, that's a very good question. And it's largely dependent on the agency and largely dependent on the particular issue that's raised. In some cases, it may be upon the private individual or entity that's raising the issue to finance their own expert opinion preparation and consultation. In some cases, they may already have done that on their behalf, which has brought about their approach to the process. In some cases, even perhaps in rare cases, a local public entity may do the same thing. And so although I hate to not answer the question squarely, it would just depend on the situation. The burden of proof, though, I would, if this is of any help, that there's really no burden of proof in terms of a one side winning or one side losing. The contribution of materials and evidence to support this position that any particular person is making is just something that gets considered by the federal agency pursuant to their duty to consider certain things and then render an informed judgment and move forward. Does that make sense?
Okay. And then the last question I have is does this apply to anything that's in the works now? If we adopt this now and it goes into effect whenever it does it apply to anything that's that's being formed now? Let's assume the BLM is proposing a wilderness. Let's say that Forest Service and that wilderness out in Josephine County out there. It's already been proposed and they're working on it. So if this isn't implemented to a later date, can it go back with something that's already started? That the action of the federal government has already started?
Also a good question. The right to coordination that is given by Congress to local governments exists from the time Congress passed that law. That right is enhanced, strengthened, and effectuated by this policy, and so it exists as we speak now in most cases, excepting some very particular statutes. But the general idea of coordination that's made law, federal law, ironically, is there already and will be there before or after you pass this, and before and after you decide not to, alternatively.
Okay. Thank you, Ryan. Thank
you. Ryan, a couple of things. When we release RFPs regarding this, Ms. Lehman brought up the fact that Fred Kelly Grant was not given the opportunity to put in an RFP. Please explain that process on RFPs. We generally don't. I'm sorry. I thought that was what you said. He didn't respond. Oh, I see. Okay. All right. Did Mr. Grant respond on the RFP? Do you recall that?
You know, I think we had. It's been a while, like a year ago. I think we had 3 responses. Somebody else made the comment about working with somebody who has experience in their county doing this. We had a member of, I think, was the Siskiyou County Board of Commissioners.
Or Modoc County, I think.
Or Modoc County, maybe. It's one of the California counties who had written a coordination document that submitted a proposal. But honestly, I don't really recall. I mean, the selection committee selected and made a recommendation to the board about who they selected and why. That wasn't even this board, if I remember correctly. It was the previous board. So I can't really answer for why the board didn't hire a specific person, except for you didn't, but the previous board had the opportunity to review the recommendation.
And then the other thing, too, is if we are challenged by a federal agency on coordination and we did not enumerate our areas of concern or have it enumerated in an ordinance, would that be an indefensible or a defensible position if we wandered into court trying to claim coordination on issues that we don't even slightly enumerate in some form? Some people said just the sheer statement of enumeration and a resolution of coordination was sufficient.
Yeah, good point. The ordinance contains in it language that states the county is exercising its rights to coordination to the fullest extent of the law. That suffices to trigger, to put the agency on notice that you want coordination, you mean business, and you want it to the fullest extent Congress has created it. Logistically speaking, assuming the ordinance is enacted, notice gets thereafter provided to all these various federal agencies in which the board is interested in coordinating with. If one of those agencies fails to provide, reciprocate in its communications to give you notice of some action that's pending and to start coordination, I'm hesitant to speak too distinctly about the legal theories that would be presented in the U.S. District Court, because it would be litigation. But I don't believe, I can say I don't believe the failure to be specific in the ordinance the way it's drafted now is going to impair the enforceability of the coordination duty by the county, provided we're dealing with one of the agencies that received notice of our intent to do it. Does that make sense?
And Mr. Chair, even though that may be the case, it doesn't mean that you may not want to further develop and enhance it by enumerating it. We think it just, so if you choose to continue to take input and still work the plan, but we also don't think it creates a liability for you by passing it now.
And I would also add that when there are various agencies, federal agencies that are particularly important, what I meant at the beginning of my comments about the reason this ordinance is drafted in general terms instead of specific, when notice is provided to those federal agencies after the ordinance is enacted, there's an opportunity for the county to express its interests even further. And once they're on notice of what our interests are, it should be no different. It won't be any different if there's a particular interest expressed to them outside of the ordinance or in the ordinance in that context.
All right, any other questions of staff? All right, no other questions of staff? And then there's still any other questions, staff will, and I think what we'd like to do is, since so many of you have taken time out of your day, rather than break for lunch, we're going to try to work through lunch and try to get to a decision today if we can, so, or during the next hour or so. So with that said, the board will begin its deliberations with staff to hold, and if we have any questions of people, we may draw people back up. So with that said, who would like to go first?
I always go first. You go first.
I think we've heard the word complex and complexity several times today. There's no doubt about that. I too appreciate the comments being made. As you can tell, we're not experts in this particular matter. That's the reason why we rely on legal counsel, both in-house and out-of-house, and with our consultant. As I've looked at this document, this 15-page document, and we have spent quite a bit of time on this, both in public session and then individually as we were handed the ordinances. I'd like to move forward because I think moving forward is better than not moving at all. And the reason why I say that is we could probably study this to death and maybe look for perfect that gets us not past good. And that concerns me a little bit. I'm also heartened that we can make changes to this as we see fit. So it's really going to become a living document more than anything else. And so because of that, then I'm inclined to go ahead and vote on us accepting this at this point.
Commissioner Rasher.
Well, first of all, I want to thank everybody that came and gave input. This is really valuable. I have been keeping score up here. There were 7 people that wanted to delay it. I would hope that Ryan and our administrators' explanations put a lot of your concerns at rest. For those of you that know me, I like to do things in a hurry. I don't like a lot of delays. I've watched government as you have, here for many, many years, and we just know how long something takes to put this off, and that's my concern. If we decide we're going to delay this to try to make a few minor changes in language, or we're going to talk to Fred Kelly Grant, and he's out of town, and or we have to go back to CSA, and then they want to get a hold of Cable Houston and get their input on it. I could see us dragging this out another 6 months, well, another 3 or 4 months before we meet again. So with all that in mind, and knowing that we have the ability to fine-tune this with amendments later on, I would be in favor of moving forward with this.
Thank you, gentlemen. Well, as chairman, I get the last word, and that's why I call my wife the chairman. But she always gets the last word at home. But in this case, I get the last word. And somebody mentioned, what is our belief system? Number one, our belief system is to try to enforce and create as much of our own rights at the local level as we possibly can. And I didn't start out a year ago at this, or 2 years ago. I started out 4.5 years ago when I went to Fred Kelly Grant's seminar with a bunch of other county commissioners, and I've been sharing this information with other county commissioners across the country, including Utah, Colorado, Wyoming, and we all are approaching a strategy. I want to thank Fred Kelly Grant for opening our eyes about what we can do. We may approach it in different ways, but I will tell you, I want to thank Mr. Grant repeatedly. I met him and talked to him. He probably doesn't remember me. I was one of many county commissioners at the time, but that was over 4 years ago. And I began the process of investigating how well this can proceed. And we did that. We started that process. Was it perfect? No, it wasn't perfect. And I was not aware of, we don't necessarily know who applies for an RFP if we put it out. I was not aware that Mr. Grant had responded to the RFP. Be that as it may, we had as much, at the time, as much input as we had, including all of Mr. Fred Kelly Grant's working documents and papers, which we reviewed extensively. And our legal staff reviewed that, and the folks up north that we pulled in. We picked up, I thought we picked some of the finest federal constitutional and land use and folks that deal with it as often as possible. So with that said, it was not a slow and I mean, it was not a real rapid kind of a thing. We've been working on this, and it was no small task asking the previous board to pass a resolution. I had one very solid vote, but yet again, it does require, and we didn't get a vote from the other commissioner at the time. So, but we did get it passed, and we began the process. So that was not the easiest thing to convince them, because it's a concept that a lot of people couldn't quite understand. They couldn't quite grasp it, and it was very hard to get down to the nuts and bolts as to how it really works. And as you know, it is complex, and you've heard that today. The issue of federal land, you know, I once went to a graduation speech, and I called it the speech of 1,000 platitudes. And the problem is, they're very inspirational, and they're like a pep rally. But when it comes down to the game and the football and how it's being passed and tossed and caught and the goals being won on the field, that's what really counts, and that's what we're talking about. We're trying to figure out how to get onto the field, and we're talking about how to play the game. Now, it's not perfect, I know that, and it's not going to make some of you happy if we proceed, but it's my wish that we would proceed, and I'll tell you why. Congress and the federal courts are the final arbiters of any issues on federal land. I know that because I spoke before Congress last March, and I testified before a secretarial order, 3310, and it would give the secretary carte blanche authority over federal lands and creating wilderness throughout the nation, and it was 12 million acres of additional wilderness he could just do with the signature of a pen. I spoke against it. 2 other governors sitting with me spoke against it, and 5 other commissioners spoke against it, and one gentleman that sells hiking gear spoke for it, and another gentleman for whoever, I can't remember who spoke for it. But the point is that nobody questioned, and these folks had a lot of legal attorneys behind it. We all understand the federal government does own those lands, okay? There's this little argument. I know you don't agree, but Congress gave them that authority. It's something called comity, C-O-M-I-T-Y. Look it up, and it's a standard. If Congress gives authority over law on a land, it then becomes Congress's authority, and the federal government owns the land. And this is a chronic argument over federal and state and local jurisdiction, and it goes on to this day, and it'll probably continue going on. But in any case, that's the case as we best know it, and a lot of better minds than I have talked about this issue. Timing is of the utmost importance. We do not have the time. I want to tell you something. I just came from a conference with other commissioners, and we have 2 other counties that are talking about bankruptcy and dissolution. What does that mean for you as a citizen of Jackson County? It means you absorb their tax rate, and our rate goes down, and all of our services therefore go down in being paid for, and you subsidize those other counties. Now, if you think that's not a reality, you better go talk to those commissioners, because I just got an earful. They have 24 months of survivability, and they'll be dissolved, and we may have to absorb them. We don't have the time. We have to do everything we can to move forward as quickly as possible. We take this information very seriously, what you provided, and we will look at every avenue to increase and improve this ordinance. It's not going to be perfect, and I've said it's not perfect, but it's the only baby we've got, and we want to make sure it gets born and moving, and we're going to move forward. So timing is extremely important for us right now. Plus the forest receipts issue, you all know that. We are fighting hard. There's two pieces of federal legislation that we must be actively involved with. So with that said, I could probably go on longer, and I probably have two already. So anyway, with that said, I'd be in support of moving this forward with and taking these exhibits as internal review for future amendments or changes that we may make. So with that said, Chair will entertain a motion on the order.
Mr. Chair, I move we approve a Jackson County ordinance relating to the federal coordination policy. The ordinance number is 2011-15.
Second that.
It moved and second. Call the roll, please.
Yes.
Yes.
Yes. Item so ordered and approved.
Before we leave that, though, we've heard several people thank this board for moving forward on that. Yes, we're the one that enacts it, but as you mentioned, I want to thank the previous board who really started this policy up. It's through hard work to get it done. So yourself and Mr. Walker and Dr. Gilmore. So thank you very much.
All right. Next item of business is 40.00, discussion and deliberations. Order number 40-01 is an order authorizing deferred compensation plans with Hartford Life Insurance Company and Variable Annuity Life Insurance Company, VALIC 258-11. Danny?
Yeah, Mr. Chair, Jackson County does provide voluntary deferred compensation plans as a benefit for eligible employees and has deferred compensation plans both with Hartford Life Insurance Company and VALIC Variable Annuity Life Insurance Company, which were most recently authorized by the Jackson County Board Order number 64607 on November 9th of 2007. Since that time, the deferred compensation plans have been restated. They've been restated in order to bring the existing plans into compliance with legislation and regulatory guidance that has been enacted or issued since the deferred compensation plans were last updated. The restated deferred compensation plans include all of the various previous amendments as well as new updated changes that have been added in accordance with federal tax legislation. The restated deferred compensation plans are intended as good faith compliance with Internal Revenue Code Section 457. There is no financial impact to the county. This is just to bring the county into compliance with the regulations governing the plans, and I do recommend your approval.
Okay, any questions, Mr.
No.
Mr.
Chair, I move that we accept Board Order 258-11 as presented.
I will second that.
Moved and second. Call the roll, please.
Yes.
Yes.
Yes. Item number 40.02 is an order authorizing intergovernmental agreement number 4609 with the State of Oregon Department of Corrections, Community Corrections, order number 259-11.
Mr. Chair, this agreement is a result of Jackson County's application to the State of Oregon, the Department of Corrections, for grant and aid funds. They're basically grant funds that fund our community corrections program for adult offenders on supervision and incarcerated. This is particular grants in response to the implementation of Measure 57. By the way, the biggest portion which has been delayed for implementation by the legislature because it largely increased the prison population. This is for the portion of the population that remain in the county and continue to be managed. With the funding from this agreement, Jackson County Community Justice proposes to maintain one full-time parole and probation officer to provide intensive supervision to those clients. Those are clients that would have otherwise went to prison, and that's why the need is for the intensive supervision. Funding also provides part-time funding, for a part-time funding for a urinalysis technician, someone to take urinalysis tests on offenders under supervision, and to pay for a portion of the tests that are administered in the program, and also to supplement current drug and alcohol treatment contracts. The agreement provides a revenue of $276,633 to Jackson County. Term of the agreement begins upon full execution. It expires June 30th of 2012. It is a revenue to the county of $276,633. It is budgeted because it was anticipated, and I do recommend your approval.
Discussion on the order.
Well, I have a question. What does the half-time urinalysis technician do the other half of the day? Does he work for us, or does he come in half? I'm just curious.
It's a half-time position,
Okay,
so
so
I don't
he'd
I
have
don't
to
know
come
what they
from
do the
another
rest of their day.
department or
But,
something. I didn't
mean,
know.
we could probably ask them, but they don't necessarily have to disclose.
Okay.
The restaurant inspector.
Mr. Chair, I move we approve Order 259-11.
I'll second that.
Vote on the second, call the roll, please.
Yes.
Yes.
Yes, item so ordered and approved. Item number 40.03 is an order authorizing partnership and co-management agreement with Oregon Youth Authority, order number 260-11.
Mr. Chair, this is also in relation to the Jackson County Community Justice Department, however, specific to the Juvenile Division, who's been working collaboratively with the state of Oregon and the Oregon Youth Authority to coordinate services for youth offenders that are in our county, both under the jurisdiction of the state and or the jurisdiction of the county. This agreement outlines areas of mutual interest and areas of concern to both Oregon Youth Authority and Jackson County Community Justice in terms of supervising those youth. Implementation of standards and practices that are coordinated between the two agencies will develop closer coordination of state and local services, maximize resources, eliminate duplication, and improve service delivery to the community. This is just an agreement of basically of how we'll co-manage youth that are both and that are in either of the systems or in both of the systems, which can also exist at the same time. There's no financial obligation by either party under this agreement. The term of the agreement begins upon full execution, and it will be jointly reviewed annually, and I do recommend your approval.
Any questions, staff?
No, it's a good deal.
All right. Take a motion on the order.
Mr. Chair, I move we approve Order number 260-11.
Second that.
All right, move and second, call the roll, please.
Yes.
Yes.
Yes, item so ordered and approved. 40.04, an order authorizing intergovernmental agreement number 136944 with the state of Oregon, Oregon Health Authority, order number 261-11.
Mr. Chair, in this case, the state of Oregon, through the Oregon Health Authority, funds services to the public water systems in Jackson County. This is to ensure reduced risk and increase compliance with drinking water monitoring and the maximum containment level requirements. Intergovernmental agreement number 136944 with the state of Oregon, Oregon Health Authority does require Jackson County to investigate occurrences of waterborne illnesses and drinking water contamination events, to respond to spills and emergencies, and to inspect water system facilities. Jackson County has provided these services for many years. We do have knowledgeable and qualified staff willing to perform these services. The agreement is reimbursement-based agreement. It has a maximum compensation limit of $183,795 to Jackson County. Term of the agreement is October 1st of 2011. Through June 30th of 2013. It does require ratification to become effective October 1st of 2011. It's a revenue that's dedicated to this specific issue in the amount of $183,795. It is budgeted as it was anticipated, and I do recommend your approval.
All right, any questions of staff on there?
Well, I have a couple questions. Danny, is there ever a chance that the state would say, you know, we can't afford that and we're going to cut it off in the middle of the program, or do they pay us before or after? How does
It's a reimbursement basis, and there is the chance that they'll do that. However, as you're aware, in the Health and Human Services program by fund, we've built reserves for each particular function. So if the state were to do that, we do have reserves that could pay for costs that we've already incurred, as well as extend the life of a particular program if that were the policy decision the board made. The other issue is that we don't, we potentially, depending on the terms of the intergovernmental agreement, can provide notice of default and opt out of providing the services to the state. We're not required to provide the services. We're doing it on behalf of the state through an intergovernmental agreement for many of the services the county does. In other instances where the state has done exactly what you just said, for example, septic inspections, septic tank installation inspections, the state reduced funding to the level that the county was subsidizing the program to, I think, tune of about $178,000 a year. We notified the state that we were opting out of providing that service and returned it to the state. We have the same option to do that here, assuming something like that happened. And we generally have that same option with any intergovernmental agreement we enter into with the state.
And looking at that amount, that looks to me like it's about 2 FTEs because 2-year contract. So if we, you know, we don't have to justify how many hours. I mean, they just give us this amount to provide the service. We don't have to say we've employed 2 people, or if we spend under that, we don't have to give any back.
No, as I said, this is a reimbursement. And so we apply for the actual expenses we incurred, and they fund us up to that amount.
Oh, up to that. Okay. All right. I understand. Okay. Thank you.
All right. Mr. Chair, I move that we accept Board Order 261-11 as presented.
I'll second that.
Move and second. Call the roll, please.
Yes.
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 I want to acknowledge we have a councilman from the city of Eagle Point here joining us today, so it's nice. And we have Miss Blair from the city of Medford. I want to acknowledge her as well, so thank you for attending.
Wasn't that fun? Thank you very much. And now I'll hereby adjourn this meeting. Thank you.
You've been watching the weekly Jackson County Board of Commissioners meeting, held every Wednesday morning at 9:30. If you have any questions or comments, you can contact the commissioners at 774-6116. You can also visit www.jacksoncounty.org and click on Video and TV Center to view many